Right. Hello everyone, welcome to Module 11. I'm here to introduce you with a no-frills introduction to the whole module. And as we all know, it starts with the desegregation cases, especially Brown versus Board of Education from 1954, where the Supreme Court decided that state laws establishing separate public schools for black and white students were unconstitutional. The decision overturned the Plessy versus Ferguson decision of 1896, which allowed state-sponsored segregation. It was a class action suit filed by citizens in Topeka, Kansas, 13 parents on behalf of their 20 children. And the plaintiffs asserted that the system of racial separation, while masquerading as providing separate but equal treatment of both white and black Americans, instead perpetuated inferior accommodations, services, and treatment for black Americans. The suit called for the school district to reverse its policy of racial segregation. The district court ruled in favor of the Board of Education, citing the Plessy versus Ferguson decision, but then the Supreme Court stated that separate educational facilities are inherently unequal. As a result, racial segregation was ruled a violation of the Equal Protection Clause of the 14th Amendment. This ruling paved the way for integration and was a major victory for the civil rights movement. The next case we'll look at is the Bowling versus Sharp case, which looks at the segregation in the District of Columbia public schools. It was originally argued a year before the Brown versus Board of Education case, but then re-argued the next year and was decided on the same day as Brown. Bowling did not address school desegregation in the context of the 14th Amendment Equal Protection Clause, but this time in the 5th Amendment of the Constitution under the Due Process Clause. The next case we'll turn to is the Brown 2. It's really the Supreme Court allowed arguments from the schools and the separate attorney generals as far as relief was concerned. In their decision, the court delegated the task of carrying out school desegregation to the district courts with orders that the desegregation occur with all deliberate speed, a phrase traceable to Francis Thompson's poem, The Hound of Heaven. Supporters of the earlier decision were displeased with this new decision. The language, all deliberate speed, was seen by critics as too ambiguous to ensure haste for compliance with the court's instruction. Many southern state schools and their school systems justified resisting, delaying, and avoiding significant integration for years because of this language. For example, one school district in Virginia did not desegregate immediately and forced its schools to close for 5 years. Now we're going to move to desegregation in other areas other than schooling. And first, in transportation, we'll look at Browder versus Gale, where the court ruled that the enforced segregation of black and white passengers on motor buses in the city of Montgomery violates the Constitution underneath the 14th Amendment. It was the district court's ruling in this case that ended segregation on Montgomery's public buses. Now we'll get into desegregation in marriage in the Loving versus Virginia case, in which the court declared that Virginia's anti-miscegenation statute, the Racial Integrity Act of 1924, was unconstitutional, thereby ending all race-based legal restrictions on marriage in the United States. Now we'll look at discriminatory intent versus desperate impact. First, we'll look at the Washington versus Davis case in 1976, which was a case regarding the application of the Due Process Clause. In that case, 2 African Americans had applied for positions in Washington, D.C. Police Department, but sued after the police department used hiring procedures that implemented a test of verbal skills which was failed disproportionately by African Americans. The court ruled against the 2 plaintiffs, finding that they used the use of the test did not violate the Due Process Clause. Then we're going to move into affirmative action and racial preferences. We'll start that off by looking at the Gruder versus Bollinger case, which is a case talking about the constitutionality of affirmative action admissions policy of the University of Michigan Law School. In that case, Sandra Day O'Connor wrote for the majority in a 5-4 decision and ruled that the University of Michigan Law School had a compelling interest in promoting class diversity. The court held that a race-conscious admissions process that may favor underrepresented minority groups, but that also took into account many other factors evaluated on an individual basis for every applicant, did not amount to a quota system that was unconstitutional. However, Justice Ginsburg and Breyer concurred, but then they kind of thought that the affirmative measures used in this case would, no doubt, be unnecessary in 25 years. Now, to get to the second half of the module, I'm going to turn to my associate, the second half of this mod squad, the Hayes effect.
In the second half of this module, we'll be looking at sex discrimination. Even if the 14th Amendment draftsman did not have gender in mind, the words of the amendment do not negate it. How does Equal Protection Clause apply to gender-based classifications? The Supreme Court applies a scrutiny test. In the first two cases of the module, we see two different applications of scrutiny. Intermediate scrutiny was applied in Craig v. Boren, and 20 years later, exceedingly persuasive justification was applied. In Craig v. Boren, Oklahoma had passed a statute which prohibited the sale of 3-2 beer to males younger than 21, but it allowed sale to females 18 and up. The Supreme Court used an intermediate scrutiny standard. They said that a state must prove the existence of a specific important governmental objective, and that law must be substantially related to achieving those objectives. The court held the statute was unconstitutional. The court determined the statistics used by the state related to the objective of traffic safety were insufficient to show a substantial relationship between the statute and the benefits intended to stem from it. Justice Rehnquist dissented, stating that the statute only needed to be subjected to a rational basis analysis. He further stated the Equal Protection Clause does not contain language about governmental objectives. He also says the statistics that the state relied on were not irrational because they were grounds enough to enact the statute in the first place. An interesting point brought up in the notes following the case is whether the government should be forbidden to legislate on the basis of equality, even if there are true generalizations in the differences between men and women. In the United States v. Virginia, the Supreme Court considered equal protection arguments as they applied to enrollment of only males in a public institution of higher education. The Virginia Military Institute only allowed male enrollment. Following a suit, the circuit court held enrollment did not violate the equal protection and did violate the equal protection and suggested a parallel institution for women. Accordingly, the Women's Institute for Leadership at Mary Baldwin College was established. The Supreme Court said that VMI failed to show an exceedingly persuasive justification for a sex-based policy of admission, and VWIL did not provide women the same benefits that VMI provided to men. Justice Scalia offered a long dissent. He deemed exceedingly persuasive justification was more akin to strict scrutiny than a rational basis test. He also said that the enemies of single-sex education have won. So far, we've seen that racial classifications are subject to strict scrutiny, and gender-based classifications are subject to intermediate scrutiny. But what about classifications based on wealth or sexual orientation? The Supreme Court recognizes that government makes classifications all the time, and thus has adopted a rational basis to describe minimal degree of scrutiny applied to these classifications. Under this level, the court says that if the classification has a relation to the purpose it was made and does not contain the kind of discrimination that the Equal Protection Clause affords protection from, it is constitutional. Beyond race and gender, the court has had a difficulty in identifying classifications that should be suspect. Focus has been on whether the classification is based on an unalterable human characteristic. Such classifications fall in the category of heightened scrutiny, except for disability, apparently, as we see in Buck v. Bell. In Buck v. Bell, which was decided in the late 1920s, the Supreme Court upheld a statute of compulsory sterilization for the unfit, including the mentally disabled. The court's decision largely reflects attitudes about eugenics of the time. In an 8-1 opinion, the court accepted the argument that Carrie Buck was feeble-minded and promiscuous, and her sterilization did not violate the Equal Protection Clause. Although the decision was never expressly overruled, eventually the statute was repealed. Next, we look at sexual orientation. In Romer v. Evans, we see an amendment passed in Colorado that prohibited city legislatures from taking any legislative action to recognize homosexuals and lesbians as a protected class. The Supreme Court said the amendment did not pass the rational basis, let alone strict scrutiny. They determined that Amendment Number 2 lacks a rational relationship to a legitimate state interest. Justice Scalia again wrote another long dissent stating that Amendment 2 did not deny homosexuals access to the political process, but made it more difficult to pass laws where they were favored. He further said the question of whether homosexuality should be given special protection, and the majority of people in Colorado said no. He also asserts the most democratic principle is unconstitutional by the majority's opinion. Moving forward, we're left with the question of what scrutiny does sexual orientation be subject to?